Well, Henshaw here again, Constitutional Crisis Channel. And this is another in a series of what I would call a continuing mantra. And I've been asked to explain to you who exactly the Constitution was for. And clearly and unequivocally, the Constitution was for lawful de jure free white state citizens. After all, we separated from England, and they talk about that in the Declaration of Independence, and they say when it's time for one people to sever the association with the other, clearly the American settlers and the English, that's who it was. And it goes back as far as the Magna Carta in 1215 also. And also the preamble of the Constitution itself says that we ordain and establish this Constitution to secure the blessings of liberty to ourselves and our posterity. Not Bill Gates, not IBM Corporation, not anyone else. We're the ones that had creator-endowed inalienable rights. And for that reason, by the way, the infamous Dred Scott case, Scott versus Sanford, 19 Howard 393, for which Roger Brooke Taney has been flayed for 150 years, having made it exactly the right decision, was correct then. It is now. It hasn't been reversed by the non-existent 14th War Amendment, which was not ratified in accordance with Article 5. That said, you non-whites in some respects may have a bit the better of it initially, because the circuit court jurisdiction as originally set up was much more friendlier for aliens to invoke. And they could get in there. That's a judicial court, and the fear at the time was that if an alien had to go into a state court, he would suffer undue prejudice and bias in that setting as against citizens of the state he was suing. I'm not sure how true that was in retrospect, but that was the idea Congress had in letting aliens get into federal circuit courts. Now, if you're blacks, Chinese, whatever, none of you had anything to do with either the proposal of the 14th War Amendment or its ratification. Therefore, you can make the argument, where is the consent of this government, of the governed, to this second-class citizenship? If that, it's not there. So, in effect, if you don't have that, you've lost nothing, and you've reverted, in my view, to the status of an alien who can now go into a federal circuit court. The way I set it up is we go into a state, supposedly a state court, exercising concurrent jurisdiction. And my concurrent brief on that subject, which is available in one of my document packets along with the admission of new states, is well worth the price. You read that and it's going to dawn on you what the hell is going on here. But that's how it gets done. Now that said, by the way, I'm making the argument in my own pleadings that being a lawful de jure free white state citizen that nobody recognizes, no department of the de facto National Socialist government recognizes this anymore. Guess what? We're aliens too, and we can do the same thing. As silly as that may seem on the surface, trust me, I have case law. I'm going to have a more complete video on this subject later, but what the Supreme Court has said, especially in early cases that remain the law of the land today. A lot of people used to look at some of the old cases they used going back to 1792, Hadrian's case, for example, and they say, oh, that's old law. Nobody uses that anymore. Well, as my first law teacher once said, the problem with that is I read the entire opinion. I didn't see an expiration date in there. Number one. Number two, all these old cases could not have been reversed by the 14th and 15th War Amendments, which even if properly enacted, and they weren't, wouldn't apply to white citizens. The reason being one of the reasons being that was not mentioned at any time to the people who ratified these amendments, that would be the effect, is to strike the word white out of the state constitutions. The Supreme Court of the United States later made that dubious ruling in a case called Neal versus Delaware. I believe the citation on that is 103 U.S. 602. I might be wrong about that one, but I'll get it for you. You can look it up down here. I'll get you the right site. But that's the case, Neal versus Delaware. But that's at best dubious, because nowhere was that mentioned that was the intent, number one. Number two, they kept secret the real intent, which was to make citizens, quote-unquote, out of corporations. That's even worse. Both of those are fraud and deceit. And guess what? There's no statute of limitations on that. Which is why we can go in there and say, wait, just, not so fast, as Lee Corso would say during college football season. This has to be the way it is, because otherwise we have no remedies. So that's the direction I'm heading here, and that I want to take you, and to make it as easy as possible for you to do it. You won't have to put in 10,000 hours in the law library like I did, or spend 7 months in jail as a political prisoner like I did. So, that said, these are what I want to help you to do, for us white citizens and for all of us who aren't. It's just a matter of figuring out who you are, the status and standing, and how you can go about invoking your rights. If I can help you do that, I've done my job. Thank you.